Hi again, Attorney Steve Vondran. We are back. We are talking business and real estate law. In this episode, we are talking Arizona injunction process in 10 minutes or less. Get ready. We are going to the Attorney Steve business and real estate whiteboard. All right, let's talk about injunctions. An injunction happens in a lawsuit when you get involved in your case and for some reason you need to enjoin or stop the other party from doing something. So when you get to the point, let me give an example. Cases that I handle, business real estate cases, for example, a foreclosure. Okay, you may get to a point where the bank or the lender or somebody is threatening to foreclose on a piece of real property in the state of Arizona. And you may say to yourself, we have to stop that. How do you stop that? You can't just yell stop. That's not going to work. You need to be seeking an injunction. Arizona injunction process. We are talking Rule 65. And we are talking general legal overview. This is not legal information. This is general information. It's not legal advice. And procedures may vary. You may have to check with your court on various procedures, okay? General Arizona injunction process. Attorney Steve, let's get going. Okay, so basically when you have your complaint, one of the things you normally need before you can file your injunction is to file the complaint, okay? So file your complaint. Now, there's a question, do you want to verify it? Verify it means under oath, and usually when you're doing that, you want to make sure everything's 100% accurate. Well, if you're not sure, you may not want to verify it, but at any rate, when you seek the injunction, you're going to want to get a declaration from your plaintiff, from your client. You're going to want to get them to give you a declaration attesting to the facts that are set forth in your complaint. Okay, so that's something to bear in mind. So the complaint's filed. Then you're saying, I need to enjoin. Again, you need something to enjoin. There has to be some threatened action that you want to stop. There has to be something that you're asking the court to stop or to order, okay? Why do we have injunctions? The main reason is to preserve the status quo, to preserve the property until the outcome of the litigation. That's what you're looking for. You're looking to prevent irreparable harm or irreparable injury, as they call it. So those are your main reasons. So if you have that, you have some issue, a business or real estate issue that pertains to that, that may be grounds to seek an injunction, okay? And an injunction, at the end, we'll talk about it in a second, when you go and get the order, you're going to be stating who the parties you're trying to enjoin, okay? So who is normally a injunction binding on? Normally on the parties, their agents, their attorneys, their employees, servants, and those in concert or participation with, in participation with, and those who are actually served with the order. So that's pretty much who you're looking to bind or stop or order as part of your injunction process, okay? And that's language pulled from the statute in Rule 65. You can look that up. And that's ARCP, Arizona Rules of Civil Procedure, okay? So that's what you're trying to do. Now let's talk about the factors. There's 4 things that a plaintiff is going to have to prove, or a party seeking an injunction, the moving party, they're going to have to prove these, okay? There's 4 elements. 1, strong likelihood of success on the merits. Strong likelihood of success on the merits. Okay, that means you have causes of action in your complaint that you're likely to succeed on, okay? I mean, if you're not going to succeed, what's the point? Why would a judge give it to you and enjoin people from doing things or order them to do things if you're not likely to prevail? That wouldn't make sense. 2, possibility of irreparable harm. Possibility of irreparable harm. Like you're going to lose the house to foreclosure. You're going to lose title, okay? That's an example for you. Balance of hardship, tips in favor of the plaintiff. Balance of hardships. This is the court going, does this make sense to grant? So that's another factor the court will look at. There's 4 factors. And the advancement of a public interest. In some cases, there will be a requirement, not all cases, to have the advancement of a public interest. So if you have the grounds to enjoin, you think you can prove these things, then you're going to file papers, baby. File papers right there, okay? You have your TRO. A TRO is a temporary restraining order. Good for 10 days, unless the court grants longer time. Good for 10 days, okay? Notice, you want to try to give notice to the other parties that you're seeking a TRO. What is notice? It's phone, fax, email. It's allowing the other party opportunity to say, hey, if they want to come and argue some of these things against you, can't prove that, can't prove that, can't prove that, you're giving them a chance, or maybe you're trying to enjoin parties that don't need to be enjoined. So that's where you want, it's not always required to have notice, but put it to you this way, I don't proceed without trying to get notice because it's important. I think most courts are going to want to see that. So you notice to your other parties. Now, the big thing, what types of papers are you filing? You can see all these right here. Lots of different papers, right? So these are the kinds of things that you're going to be looking at. And finally, you're going to have a TRO application. You're going to be stating your facts. You're going to be stating your law. Memorandum of points and authorities. You're going to be saying why you're entitled to relief. You're going to be saying why you're likely to succeed. You're going to be stating why the balance tips in your favor. You're going to be stating why there's irreparable harm and injury that you're going to be facing. You're going to be, if you have a public interest, you're going to put that forward. You're going to let the judge know what the public interest is, okay? So your application, and we have what's called an OSC, that's an order to show cause. So and this is a document you're going to prepare that the court signs off on, and they send it over to the other party saying, and what will typically happen if you can prove these things is you'll get your TRO, you'll get your short-term relief, and then you'll be seeking the longer-term relief, which is the preliminary injunction. That's why I tell my clients, there's a lot of work involved in these because it's not only getting the TRO, appearing personally on the TRO, but it's also then coming for the preliminary injunction, preparing, there'll be opposition, there'll be a reply, there'll be, likely an appearance, not always, but likely an appearance on that motion as well. So you're going to have that, an order to show cause, which I can't go into it on this video. We hope to put some sample documents on our website, and you can find us on ScribD where we sell some of our documents. Plaintiff's affidavit, as we talked about, affidavits verifying the things that have gone on in the complaint. You have your exhibits. You may have certain requests for judicial notice. That's RJN, request for judicial notice. And that's basically asking the court to take notice of certain documents, okay? And then you have your defendants, your attorney will give a written certification of the attempts to give notice and their attempts to basically notify the other party of the TRO hearing. So this is part one. Stay tuned. Part two coming up. You don't want to miss it.